Very good evening, all the participants. Today we will be covering the case laws. Some of the case laws we covered yesterday, I think up to case law number 27 or so. Now let me share this file with you. So this is 28th case law. So 27 we covered yesterday. So, and I hope my screen is visible. Is it visible?
Yes, yes.
Yes.
Yes, sir.
So this was the case.
Sunil Kumar Jain versus
Suresh Bhatt.
Sundaresh Bhatt and others.
Hmm.
Supreme Court has clarified that intricacy that arose on the claim for payment of wages, salaries before corporate insolvency resolution process (CIRP) during CIRP and in liquidation of a corporate debtor. Brief background: the National Company Law Appellate Tribunal dismissed an appeal preferred by the workmen employees of Messrs. AVG Shipyard Limited, corporate debtors against the National Company Law Tribunal's order denying relief to them with regard to their claim relating to salary for the period involving corporate insolvency resolution process CIRP and the period prior thereto. The aggrieved by the said order, workmen and employee preferred appeal before the Honorable Supreme Court. The issue dealt was with respect to wages, salary of the workmen employed during CIRP period and the amount due and payable to the respective workmen employed towards pension fund, gratuity fund and PF. Contention, sir, थोड़ा सा slide. The appellant, that is workmen and employee, contended that the salary and wages dues payable to them during CIRP period will be qualified at CIRP cost under section 5 subsection 13 of the IBC Code 2016 and are liable to be disbursed even prior to the amount distributed under section 53 of IBC. It was further submitted that the PF, gratuity and pension fund amount remain outside the liquidation under section 36(4) of IBC.
Outside the liquidation estate, he means to say. So we can say liquidation estate.
Okay.
Yes.
Outside the liquidation estate, right?
Right. Yes, please.
On the other hand, the respondent contended that the wages and salary claimed by the appellant who have done no work during CIRP period and have not assisted to RP liquidation during the CIRP would not fall within the parameter of CIRP cost within the definition of section 5 subsection 13 class C of IBC. Conclusion is that in the 5 years from its enactment of IBC, Honorable Supreme Court has adjudicated upon various matters under IBC and provided certainty on interpretation of key concepts under it. These developments have enriched the jurisprudence of insolvency in the country. The current judgment propounded by the Honorable Supreme Court clarify the position of workmen, employee and set the law clear regarding the claim towards wages and salary for the period during CIRP can only be included in CIRP cost if it is established that the IRP resolution professional manage the operation of the corporate debtor as a going concern during the CIRP and that the concerned workman employee actually work during the CIRP and not otherwise.
So this is the case. So what this case says that simply every wages and salary will not be counted towards insolvency resolution process cost. So only in the case the employees have worked during insolvency period, only then it will be counted as CIRP cost otherwise. This is the conclusion. Yes, next.
Victory Iron Works Limited and Jitendra Lohia and others. IBC developments right created in favor of corporate debtor constitute property within the meaning of expression under section 3 subsection 27 and would constitute assets within the meaning of section 18 subsection F and section 25 subsection 2 clause A of IBC. Exclusion of assets owned by third party but in possession of corporate debtors held under the contractual arrangement from definition of expression assets is limited to section 18. In other words, explanation under section 18 does not extend to section 25. Case background: corporate debtor Avani Towers Private Limited, ATPL, property in question, a 10.19 acre land parcel at Ram Rajatala Station Road, Howrah, West Bengal. Ownership and agreement. The land is legally owned by Energy Property Private Limited, PPL, which acquired it with the financial assistance from ATPL. ATPL hold 40% of EPPL shares capital and has a joint development agreement JDA with the EPPL concerning property. Concerning the property, the Victory Iron Works Limited VIWL occupies a portion of the land that is 10,000 square feet under a leave and license agreement and claim additional occupation based on an oral understanding.
Ajay
Insolvency.
Jaiswal ji is aware about this case. Ajay Jaiswal ji?
Yes, sir.
है ना? हाँ.
I was part of this case actually.
हाँ.
Thing is that the Victory Iron is our CD was Avni Towers. We were the liquidator of Avni Towers,
Okay.
and the Victory Iron Works is the third party where it was working on the property of the Avni Towers.
Right. So
There
it
is
was
a
some sort of subcontractor.
correct. So they were vacating the plot actually, and they had a joint development agreement with the CD. So this was the case actually. So it was fought, and in the finally it was been awarded that he.
So prior to commencement of CIRP, VIWL was working on that property, Victory Iron Works.
Yes, sir. Yes, sir.
And now
When
the question of
we
custody and control came.
right,
They have to vacate the property.
we went there, and they've stood. They've given goons around. मतलब उन्होंने गुंडे खड़े कर दिए थे हमारे आगे, मतलब पूरा लेबर्स को भड़का के हमारे सामने वैसा हो गया था सिचुएशन. तो देन वी हैव टू इंटरवेन द पुलिस हेल्प. हमने असिस्ट मांगा था, पुलिस का पूरी टीम गई थी पूरी. तो वी हैव टेकन द कस्टडी, सिंबॉलिक कस्टडी. वी अपॉइंटेड अवर सिक्योरिटी गार्ड्स एंड अदर.
यस. हाँ, पढ़िए पढ़िए.
फैक्ट से पढ़ना सर, कुछ पीछे.
हाँ, पढ़िए पढ़िए, कोई पूरा पढ़ लीजिए. हाँ जी.
The subject matter of controversy in these appeal was land of an extent of about 10.19 acre. Company E, which was the ostensible owner of the said property in whose name the title stands. Company A, which was the corporate debtor in respect of whom CIRP had been initiated, not only provided finance to E for the purchase of the said property, but also hold 40% of the share capital in E. Apart from holding a joint agreement with E in respect of the property in question, applicant V was claimed to be in possession of the property in entirety, partly by virtue of a leave and license agreement and partly by virtue of an oral understanding. The first meeting of the committee of creditors was held. Thereafter, the suspended board of directors of the corporate debtor informed the resolution professional that E were forcefully removing the security guard from the property. Therefore, the resolution professional filed an application before the adjudicating authority under section 25, read with regulation 30, of IBBI, Insolvency Resolution Process for Corporate Debtors, Corporate Person, Regulation 2016, praying for a direction to E and other, including B, not to obstruct the sole and exclusive possession of property, and also for the issuance of direction to the local district administrator to give proper assistance to the resolution professional in taking possession of the property so as to discharge his duty. Discussion and analysis. From the rival contention, it appears that two issues arise from consideration. They are: what is the nature of the right interest that corporate debtor has over the property in question for the purpose of deciding the inclusion of the same in the information memorandum prepared by the RP under Regulation 36 of Regulation, and second, whether NCLT and NCLAT have exercised a jurisdiction not vested in them in law by seeking to recover or protect the possession of the corporate debtor. Next is the IBC is divided into 5 parts, with part 1 containing the preliminary, part 2 containing the provision dealing with insolvency resolution and
इसको छोड़ दीजिए,
liquidation.
ये छोड़ दीजिए,
Yes.
सेकंड पैरा पढ़ लीजिए.
Okay. Interestingly, the code contains provision of definition of the word at 3 different places, namely section 3, 5 and 79. Section 3, which is in part first, contain the definition of the word and phrases, and these definitions are applicable throughout the code unless the context otherwise requires. Section 5 contain definition applicable to words and phrases used in part second alone. Similarly, section 79 contains definition of the word and phrases appearing in part third. In other words, the definition in section 5 and 79 have limited application to respective part in which they appear, but the definition in section 3 apply to the code entirety, para 18. It may be noticed from section 18 and 25 that the word assets and not the word property is what is used in these provision. Though the word property is defined in section 3 subsection 27, but the said word asset used in the section 18 and 25 is not defined in IBC. It is seen from section 3 subsection 37 that it make a reference to 7 different enactments to which one can take recourse for finding the definition of the word expression used not defined in the code. Definition of assets. The court noted that while IBC does not explicitly define the assets, the term encompasses the bundle of rights and interests held by the corporate debtors. The right arising from JDA and financial contribution qualify as property under 3 subsection 27 of IBC, and thus assets under section 18F subsection F and 25 subsection 2 clause A inclusion in CIRP. The court held that development right held by ATPL over property are to be included in CIRP process. The RP is entitled to take control of these rights and include them in IM, ensuring they are considered in resolution plan. Jurisdiction over third party occupants regarding VIWL occupation beyond the licensed area, the court upheld the decision of the NCLT and National Company Law Appellate Authority NCLAT, which protected the VIWL's right over 10,000 square feet covered by leave and license agreement, but did not recognize the claim over entire property. The court affirmed that insolvency authority have jurisdiction to manage the assets of corporate debtor, including development right, and can seek assistance from local authority to prevent obstruction.
So actually, if somebody is sitting on your land and you have got development rights, so naturally you have got the right to vacate that property, vacate it. So in this case, this party VIWL, it was in possession of certain property of the CD, which was required to be vacated. This was the issue. Next. Yes, please.
Abhishek Singh versus Huhtamaki PPL Limited. Huhtamaki. IBC section 12(8) does not specifically mention withdrawal of CIRP application where COC has not been constituted, but at the same time it does not debar entertaining application for withdrawal even before constitution of COC, and therefore application filed under section 12A for withdrawal cannot be said to be kept pending for constitution of COC, even where such application was filed before the constitution of COC.
Actually, if we see section 12A, so section 12A says that committee of creditors with the 90% vote shares.
Okay.
So section 12A makes a reference to the committee of creditors. So that means only committee can authorize. But if you go to the regulations, then regulations clearly specify the different situations. But so far as the section is concerned, section is making a reference to the committee of creditors. Yes, please.
Can application for withdrawal of a corporate insolvency resolution process CIRP under section 12A of IBC be entertained before the constitution of the committee of creditors COC, especially if a settlement has already taken place? Fact: the respondent number 1 operational creditor file and petition under section 9 to initiate CIRP process against the resolution number 2 corporate debtor, and same was admitted by NCLT and IRP was appointed. Thereafter, prior to constitution of COC, IRP along with operational creditor filed an application under regulation 30A of IBBI insolvency resolution process for corporate person regulation 2016, and under section 12A seeking withdrawal of CIRP petition filed against the corporate debtor on the ground that the corporate debtor and the operational creditor entered into settlement agreement and settled dues of the concerned creditors. In the meantime, an appeal was preferred against the NCLT orders on the ground that section 9 petition was not maintainable as there was a pre-existing dispute. However, said appeal was withdrawn before the NCLAT with liberty to apply for revival of the appeal in case of settlement failed. The NCLAT, while allowing the withdrawal of appeal, granted stay of formation of COC, held that the application had been filed prior to the constitution of COC, the settlement had been arrived at within 2 days of the admission order. The payment as per the settlement had been made within the next 5 days, that is in a week time from the date of admission. The application for withdrawal was filed on 10th day. The NCLT ought to have immediately taken the decision on the application once the party had settled the dispute even before the COC had been constituted. The application ought to have been allowed then and there rather than await the other creditor to jump into the fray and allow the IRP to proceed further. On behalf of appellant, number of order of instant court have been relied upon, wherein power under Article 142 of Constitution was exercised to approve the settlement and permit withdrawal of cases wherein CIRP had been initiated. One could have also done the same, which would have been an easy way out, but considering the order passed by NCLT rejecting the application for withdrawal, and further the IRP and 3 other operational creditors having filed an intervention application embarking upon to decide the issue raised and as to what should be the course adopted by NCLT in dealing with the withdrawal matter before constitution of COC.
So this was the case. Actually, they said they should have allowed this application. I know. They should have allowed this application there and then. Why you are coming to Supreme Court? So they said that when settlement has been arrived at within 2 days of the admission order and payment also has been made within next 5 days, so then the NCLT ought to have immediately taken the decision of the application. Right? So this was the case. So it's basically says the crux is that application can be withdrawn even after its admission, but before constitution of CUC. Yes, please.
Mojarware Karmchari Union through President Mahesh Chand Sharma versus Union of India. Laffer, the Supreme Court's decision in Mojarware Karmchari Union through President Mahesh Chand Sharma versus Union of India and others, writ petition number 421 of 2019, delivered on May 2nd, 2023, addressing the constitutionality of Section 327, subsection 7 of Companies Act 2013 in the context of liquidation proceeding under Insolvency and Bankruptcy Code 2016. The case background: the petitioner Mojarware Karmchari Union, representing the workmen of Mojarware India Limited, along with other petitioner, respondent, Union of India and others. Legal challenges: the petitioner challenged the constitutionality of Section 327, subsection 7 of Companies Act 2013, which exclude the applicability of Section 326 and 327 dealing with the preferential payment in case of liquidation under IBC. They argue that this exclusion adversely affected the priority of workmen's dues, violating the Article 14 and 21 of Constitution of India. Supreme Court observation and ruling: district legal framework. The court noted that IBC provides the comprehensive and time-bound framework for insolvency resolution and liquidation, distinct from the Companies Act 2013 exclusion of Section 326 and 327 in IBC proceeding was intentional to maintain this distinct framework. Waterfall mechanism under IBC, Section 53 of IBC outline waterfall mechanism for distribution of assets during liquidation. Under this mechanism, workmen dues for a period of 24 months preceding the liquidation commencement date and date are treated pari passu with the dues of secured creditors who have relinquished their security interest. Constitutional validity: the court held that Section 327, subsection 7 of Companies Act 2013 is not arbitrary or violating of Article 14 and 21 of the Constitution. The provision serve this objective of IBC to create a uniform insolvency framework and balance the interest of various stakeholders. Dismissal of writ petition: the court dismissed the writ petition upholding the validity of Section 327, subsection 7, affirming the applicability of IBC provision in liquidation proceeding. Significance: the judgment clarified that liquidation proceeding under IBC distribution of assets is governed exclusively by the IBC provisions, especially the waterfall mechanism under Section 53. It underscores the legislative intent to create a distinct and uniform insolvency framework, ensuring equitable treatment of all stakeholders, including workmen.
Actually, if you see, in Companies Act also, there are liquidation provisions. So those provisions are different from IBC. So here the constitutionality of Section 327, subsection 7 was challenged, which excludes the applicability of Section 326 and 327 in cases of liquidation under IBC. But Supreme Court said that this is in order. Yes, please. Next.
Suresh Kumar Reddy versus Canara Bank. IBC, once NCLT satisfied that default has occurred, there is hardly a discretion left with the NCLT to refuse admission of application under Section 7. Case background: corporate debtor Mrs. Kranti Edifice Private Limited, financial creditor, Canara Bank, successor of Syndicate Bank, successor to Syndicate Bank, appellant Mr. Suresh Kumar Reddy, suspended director of corporate debtor, Canara Bank, file an application under Section 7 of IBC against the Messrs. Kranti Edifice Private Limited for default on a secured overdraft facility and outstanding bank guarantee amounting to approximately 74.5 crore and 19.16 crore respectively. The NCLT Hyderabad bench admitted the application on June 27, 2022, initiating the corporate insolvency process and declaring a moratorium under Section 14 of IBC. The appellant challenged this order before NCLT and NCLAT, which dismissed the appeal on August 5, 2022. Subsequently, the appellant approached the Supreme Court. Fact, this syndicate bank was merged into Respondent Financial Creditor Bank. The corporate debtor had availed the credit facility from Respondent Bank and letter of sanction was issued by the financial creditors by which credit facility were sanctioned to the corporate debtor for 1 year, valid up to 28 February 2017. Since the liability of the corporate debtor under the secured overdraft facility was outstanding towards the bank guarantee and financial creditor, bank filed an application under Section 7 against the corporate debtor before NCLT. The NCLT admitted the said application and declared a moratorium. Aggrieved by the NCLT order, appellant suspended director of corporate debtor filed an appeal before NCLAT. The NCLAT by impugned order had dismissed the said appeal. The appellant filed instant appeal before the Supreme Court on the ground that NCLT was not under an obligation to admit the application filed under Section 7, and for good reason. NCLT could have refused to admit the application filed under Section 7. Once the NCLT satisfied that the default has occurred, there is hardly a discretion left with NCLT to refuse admission of application under Section 7. Thus, even non-payment of a part of debt when it becomes due and payable will amount to default on the part of corporate debtor. In such a case, an admission order under Section 7 must follow. If the NCLT finds that there is a debt but it has not become due and payable, the application under Section 7 can be rejected. Otherwise, there is no ground availing to reject the application. In the instant case, it must be noted that the amount payable by the corporate debtor also included in amount repayable under fund-based credit facility of secured overdraft. The facility granted to the corporate debtor was not confined to bank guarantee. Moreover, a demand notice under Section 13, subsection 2 of Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 surface dated 29th August 2018 was issued by the respondent bank. As the corporate debtor did not honor the said notice, the original application for recovery has been filed by the respondent before the debt recovery tribunal. Moreover, the corporate debtor acknowledged the debt on 5th May 2019 to the extent of 63.36 crore rupees. Moreover, the balance sheet as of 31st March 2019 of corporate debtor reflect the said liability of the corporate debtor. Supreme Court observation and ruling. Obligation to admit application. Supreme Court held that once the NCLT is satisfied that financial debt exists and default has occurred, it is obligated to admit the application under Section 7 of IBC. The court emphasized that the NCLT does not have discretionary power to reject such application based on extraneous consideration. Distinction from Vidarbha judgment. The appellant relied on Supreme Court's decision in Vidarbha Industry Power Limited versus Axis Bank Limited, arguing that NCLT had discretion to reject application even when debt and default are established. However, the court clarified that Vidarbha judgment was based on its unique fact and does not establish a general rule. The court confirmed the principle laid down in Innovative Industry Limited versus ICICI Bank and E.S. Krishnamurthy versus Bharat High Tech Builders, which mandate admission upon proof of debt and default. One-time settlement proposals, the appellant contended that the bank refused to accept OTS proposal should have been considered. The court noted that while OTS negotiation may be ongoing, they do not impede the initiation of CIRP. Once default is established, the bank guarantee and alleged default. The appellant argued that the bank's refusal to extend the bank guarantee led to the default. The court observed that bank guarantee are independent contract and their invocation does not negate the existence of default on the primary debt obligation. Significant, the judgment reinforces the mandatory nature of admitting application under Section 7 of IBC upon establishing debt and default, limiting the NCLT's discretion in such matter. It distinguishes the Vidarbha decision as specific and not a precedent for discretionary rejection of application under Section 7. The ruling provides clarify for financial creditor and corporate debtor regarding the initiation of insolvency proceeding.
So the case here was that there were fund-based facilities and non-fund-based facilities. So this borrower was offering this OTS proposal also. And the borrower's main argument was that because the bank guarantees were invoked or bank guarantee facility was not extended, so it led to default. Because sometimes instead of making payments, the borrower was utilizing those bank guarantees. भाई आपने किसी पार्टी को पेमेंट करना है तो आप क्या करते हो, कई बार उसको बैंक गारंटी दे देते हो इंस्टेड ऑफ मेकिंग पेमेंट। तो अगर वो बैंक गारंटी बैंक रिवोक कर लेगा तो क्या होगा, जिस पार्टी को आपने बैंक गारंटी दी है व्हाट ही विल से यू मेक माय पेमेंट। सो दिस पार्टी इज सेइंग दैट द बैंक्स रिफ्यूजल टू एक्सटेंड बैंक गारंटीज led to the default. But court said that bank guarantees are independent contracts and their invocation does not negate the existence of default on the primary debt obligation. So if a default has occurred, so then Section 7 application has to be admitted.
Right.
Yes, next.
Glue Creek Capital Private Limited versus State of West Bengal. IBC where petitioner unsecured creditor challenged the interim order of High Court extending transit anticipatory bail granted to respondent suspended director of corporate debtor, but petitioner was neither informant nor a party to proceeding pending before High Court and was totally unconnected with FIR lodged against respondent by financial creditor. Petitioner had no locus in matter and thus special leave petition filed against High Court was to be dismissed. Corporate debtors Messrs. Leading Hotels Limited undergoing insolvency proceeding under IBC, appellant Glue Creek Capital Private Limited and unsecured financial creditor of LHL, respondent State of West Bengal and others including individuals who were granted transit and anticipatory bail by the Delhi High Court. Fact, the CIP was initiated against the corporate debtors and RP was appointed during the pendency of insolvency proceeding before the NCLT and order was passed directing the RP not to proceed with the approval of resolution plan. Thereafter, the petitioner, unsecured financial creditor of the corporate debtor, filed an appeal against the said order before the ironclad, and same was dismissed by ironclad. The financial creditor, who were also member of the committee of the creditors, lodged FIR against the respondent number 3 to 5, who were suspended director of corporate debtor. Held, the petitioner contend that petitioner is an interested party to challenge the extension of anticipatory transit bail granted to the respondent, who are suspended director of the company against which insolvency proceedings are pending under IVC. It is pertinent to note that the order impugned by the petitioner arises out of the proceeding initiated by the respondent before the High Court challenging the first information report FIR lodged against them. It is an admitted fact that petitioner is neither the informant nor a party to the proceedings pending before the High Court, and is totally unconnected with FIR lodged by the financial creditor, who were also a member of the committee of the creditor. In view of the facts and circumstances, it is open that petitioner has no locus in matter, and thus permission to file a special leave petition is dismissed. Supreme Court observation and ruling, scope of section 66. The court emphasized that section 66 subsection 1 of IVC empowered the adjudicating authority to pass order against the person who were knowingly party to the conduct of the corporate debtors business with intent to defraud creditors. This provision does not extend to third parties or external entities that had business dealing with CD but were not involved in its management or operation. Clarification request denied. The Supreme Court declined to provide the clarification sought by Gluckrich, stating that the application was an indirect attempt to revisit the earlier dismissal of SLP. The court maintained that its previous order did not preclude the resolution professional from considering appropriate action under IVC, but reiterated the limitation of section 66 concerning the third party. Significance: the ruling delineates the boundaries of section 66 of IVC, affirming that its provisions are confined to individuals directly involved in corporate debtors management who have conducted the business with fraudulent intent. Third, parties are external entities even if they engage in transaction with the corporate debtor, not subjected to proceedings under this section. Resolution professionals seek redress against such third party must explore alternative legal remedies outside the purview of section 66.
Basically, this case is based on the provisions of section 66. So section 66 talks of fraudulent transactions. And it says if somebody is concerned with the management, then he can file the application. So section 66, it says if during the CIRP or liquidation it is found that any business of the corporate debtor has been carried out with an intent to defraud creditors or for any fraudulent purpose, the adjudicating authority may, on the application of the RP, pass an order that any persons who are knowingly parties to the carrying on of the business shall be liable to make such contributions. So basically, section 66 deals with the fraudulent transactions. So what it says, basically there are three parties. One, the RP or the liquidator who will be filing the application, adjudicating authority who will declare such transactions as fraudulent, and the persons of the management. Now suppose an application has been filed under section 66 and High Court has granted anticipatory bail. So the question is whether financial creditors who are members of the COC, whether they can challenge this grant of anticipatory bail to the suspended board. So Supreme Court answered this question in the negative. So they said that the persons should be directly involved in the corporate debtors management who have conducted business. So third parties, even if they are engaged in transactions with the corporate debtor, are not subject to proceedings under this section. So basically they say that action can be taken against the erring management on an application filed by the RP or liquidator, and the adjudicating authority will pass this application. But the third parties who are not concerned in this scenario, so they cannot file an appeal on this issue. Here the High Court granted stay to the suspended board of directors. But this financial creditors, they filed the SLP before Supreme Court, which was dismissed. This was the case. Yes, please. So this is a case on section 66.
Right.
Yes, please. Next.
Manchal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited and others. IVC dues of secured creditor who relinquished his security have much higher priority under section 53 subsection 1 than dues of secured creditors who opt to enforce his security interest. IVC where appellant electricity supplier had government participation and its function could be replicated by other entities, both private and public. Dues or amount payable to electricity supplier towards supply of electricity were not government dues and appellant was secured creditor under IVC. During the insolvency resolution process, a secured creditor is not permitted to realize its dues by initiating any proceeding. This is by virtue of section 14 subsection 1 clause C, which enable the imposition of an moratorium period during which a secured creditor is precluded from bringing any action to foreclose, recover, or enforce any security interest. Secured creditors' rights are restored only in event of failure of insolvency resolution process at stage of liquidation. Case background. Appellant the possible Vidyut Vitran Nigam Limited, respondent Raman Ispat Private Limited, corporate debtor. Timeline of events
We
in
can
2000.
we can read from facts only, directly
Okay.
facts.
Corporate debtor entered into agreement with the appellant PVBNL for supply of electricity, which provide that outstanding electricity dues would constitute a charge on the assets. Clause 8 of agreement mentioned in that parties would be governed by the 2003 Act. PBBNL and electricity supplier raised bill for supply of electricity to the corporate debtor from time to time. Since the dues remain unpaid, the PBBNL attached the corporate debtor's property. The corporate debtor initially underwent resolution process under IVC. However, that process was not successful. It therefore became subject to liquidation. The liquidator alleged that unless the attachment order of the district collector and tahsildar were set aside by NCLT, no buyer would purchase the property of the corporate debtor due to uncertainty about the authority of the liquidator to sell the property. The liquidator also took the plea that PBBNL claim would be classified in order of priority prescribed under section 53 of IBC, and PBBNL would be entitled to pro rata distribution of proceed along with other secured creditor from sale of liquidation assets. This definition of secured creditor, which means a creditor in favor of whom security interest is created. Such security interest was defined under IBC as a right, title, or interest or a claim in property created in favor of or provided for a secured creditors by a transaction which secure payment or performance of an obligation and includes a mortgage, charge, hypothecation, assignment, and encumbrance or any other agreement, arrangement securing payment or performance of any obligation of any person. The priority of claim indicated in the hierarchy of preference under the waterfall mechanism is therefore firstly involve resolution process cost and
So
liquidation
we can,
cost.
this
Second,
is section 53, we can skip this. है ना?
okay, okay.
Yes.
Supreme Court observation and ruling. Supreme Court held that Section 238 of IBC, which contain a non-obstant clause, override conflicting provision in other law, including Electricity Act 2003. This means that during insolvency proceeding, the IBC provisions take precedence over those of Electricity Act. Classification of PVBNL's claim. The courts determined PVBNL's claim for unpaid electricity dues, classified it as an operational creditor under IBC. Consequently, PVBNL's recovery of dues must adhere to IBC framework, especially the waterfall mechanism outlined in section 53, which prioritized claim during the liquidation. Distinction from Rainbow Papers case, PBBNL referenced the Supreme Court decision in the State Tax Officer versus Rainbow Papers Limited to support its claim. However, the court distinguished the present case, noting that Rainbow Paper Limited did not consider the IBC's waterfall mechanism and pertained to resolution process, whereas the current case involved liquidation release of attached property. The court upheld NCLT and NCLAT's decision to release the attached property to liquidator, facilitating their sale and equitable distribution of proceeds among the creditors as per IBC. Significance, the judgment reinforced the IBC overriding effect over the other statute in matter of insolvency and liquidation, ensuring a uniform and equitable process for distribution of debtors' assets. It clarifies that statutory dues such as electricity charges do not automatically grant the creditor a secured status outside the IBC provision. Creditor must participate in the insolvency process and recover dues in accordance with the IBC established hierarchy.
If you remember Rainbow Paper case, so what was Rainbow Paper case? In Rainbow Paper case, the dues of the state tax, Gujarat. So it was talking of Gujarat VAT Act. But here the process is of liquidation, not of CIRP. So suppose there is an electricity supplier. Various questions were there in this case. Number one, whether electricity is being supplied by government departments also and by private sector also. So first question, whether they can be termed as government dues, the answer is no.
No.
Second point was, suppose there is a clause. So in this Electricity Act also there was a clause. So it said that the this PVVNL will get a charge on the property, and these properties were attached because these power bills were not paid. Now the question came that once a company has come into CIRP or liquidation, then what will happen to the operational dues, because electricity dues are operational dues. So then they said that this charge has to be vacated. Okay? So this charge has to be vacated and PVVNL will be paid as operational creditor. This was the case. And it does not become a secured creditor. So they distinguished it from Rainbow Paper judgment also. They said that Rainbow Paper was CIRP case, here it is liquidation case. So NCLT, NCLAT and Supreme Court all decided to release the attached properties to the liquidator. This was the case. Next.
Vishal Chelani and others versus Devashish Nanda. In view of section 5 subsection 8 clause F, no distinction is per se made out between different classes of financial creditors for the purpose of drawing a resolution plan, and by introduction of explanation to section 5 subsection 8 clause F, home buyers and LRTs of real estate projects are included in class of financial creditors. Case background: parties involved: appellant, the home buyer who had invested in real estate project developed by Bulanan Bill Tech Private Limited, respondent Devasis Nanda, resolution professional of Bulanan and Bill Tech.
बुलंद बोल दीजिए, बुलंद बुलंद.
अच्छा, Buland and Bill Tech. Buland
बुलंद
and Bill
बिल्डर.
Tech Private Limited. Timeline of event. The appellant, aggrieved by the delay in completion of the project, approached the Uttar Pradesh Real Estate Regulatory Authority (UP-RERA) and obtained decree for refund with interest. Subsequently, insolvency proceedings were initiated against the Buland Buildtech Private Limited under the IBC. In the resolution plan presented during the corporate insolvency resolution process, a distinction was made between home buyer who had obtained RERA decree and those who had not. The former were offered less favorable terms. The appellant challenged this distinction before National Company Law Tribunal and National Company Law Appellate Tribunal, but both appealed the resolution plan. The appellant then appealed to Supreme Court.
So the question here is, suppose there are two types of home buyers. Some buyers have approached RERA and they got a decree, and there are others who did not approach RERA.
Right.
So whether a distinction can be made between these two types of people, this was the case.
RERA people will be preferred than non-RERA.
Here it was done reverse.
Okay.
It says former were offered less favorable.
Less. Right.
Yes.
The appellant were the home buyer who had opted for allotment in real estate project of respondent company. Aggrieved by the delay in completion of the project, the appellant approached the UP-RERA, which by its order upheld this entitlement to refund the amount deposited by them together with interest. In the meantime, insolvency proceedings were initiated, and in the course of proceeding, after the due consultation by the Committee of Creditors, a resolution plan was presented to NCLT. In the said resolution plan, a distinction was made between home buyers who had opted or elected for other remedies such as applying before the RERA and having a court order in their favor, and those who did not approach authority under RERA Act were given benefit of 50% better terms than that given to those who approaches RERA or who were decree holder. The aggrieved by the said resolution plan, the appellant filed their application before NCLAT, and the same were rejected by NCLAT, and their appeal too were unsuccessful. Held in the event that it is evident that with the introduction of the explanation, home buyer and allottage of real estate projects were included in class of financial creditor because financial debt is owed to them. On a plain reading of section 5 subsection 8 clause F, no distinction is per se made out between different classes of financial creditor for the purpose of drawing a resolution plan. The RP view appeared to be that once an LRT seeks remedy under RERA and offers for return of money in terms of the order made in her favor, it is not open for her to be treated in the class of home buyer. Instant court is unpersuaded by the submission. It is only home buyer that can approach and seek remedy under RERA. No others. In such circumstances, to treat a particular segment of that class differently for the purpose of another enactment on the ground that one or some of them had elected to take back the deposit together with such interest as ordered by the competent authority would be highly inequitable. As held in Natwar Agrawal, HUF versus yes, such developers and builders private limited, dated 2nd August 2023 by NCLT, underlying claim of aggrieved party is crystallized in the form of a court order or decree that does not alter or disturb the status of a concerned party. In the instant case of a litigation as a financial creditor, furthermore, Section 238 contains a non-obstant clause which gives override effect to its provisions. Consequently, its provision acquire primacy and cannot be read as a subordinate to RERA Act. In any case, the distinction made by the RP is artificial. It amounts to hyper classification and fall afoul of Article 14. Such an interpretation cannot be counter cannot
Continuous.
be countered. Supreme Court observation and ruling. Home buyer as a financial creditor, the court reaffirmed that the following the 2018 amendment to section 5(8) subclause 5 of IBC amount paid by LRTs under real estate project are considered financial debt, and such LRTs are financial creditor. No discrimination based on RERA decree. The court held that obtaining a decree under RERA does not alter the status of a home buyer as a financial creditor. Therefore, differentiating between home buyer based on whether they had obtained RERA decree is unjustified.
So this was the judgment.
The violation of Article 14. The court found that differential treatment of home buyer violating of Article 14 of Constitution of India, which guarantee equality before the law. Overriding effect of IBC. Invoking Section 238 of IBC, the court emphasized that the provision of IBC have an overriding effect over other law, including RERA. The President cited the court referred to the decision in Natwar Agrawal HUF versus.
Last पढ़ लीजिए, significance पढ़ लीजिए बस.
Okay, see. The judgment clarify that home buyers who have secured decree under RERA remain financial creditors under IBC and must be treated equally in insolvency proceeding. It ensures uniform treatment of all home buyers, reinforcing their rights and providing clarity on interplay between RERA and IBC.
Yes. Next.
Dilip B. Arika versus Union of India, IBC, when there is no violation of natural justice under Section 95 of Section 100, as a debtor is not deprived of an opportunity to participate in the process of examination of application by RP, and no judicial determination take place until NCLT decide under Section 100. Provision of Section 95 to Section 100 are not unconstitutional as they do not violate Article 14 and Article 21 of Constitution. Fact, the instant petitioner filed by the petitioner before the Supreme Court challenged the constitutional validity of Section 95 to 100 of Insolvency and Bankruptcy Code 2016. The petitioner contended that IBC is an invasive in rem proceeding and is highly prejudicial against the respondent Union of India, and before initiating proceeding for insolvency under IBC and appointment of a resolution professional RP are at the minimum. Before the RP take any action, there must be a determination by a judicial body of existence of a debt. It was contended that after the filing of an application under Section 95 without judicial adjudication or intervention, the following ought not to take place automatically, that is, an automatic interim moratorium, automatic appointment of RP subject to worthiness of a RP, seeking information from guarantor and the resolution professional, examining the information received and submitting a report.
So this is a case law based on Part 3. So Part 3, as you know, there is a concept of interim moratorium also, which starts simply on the date of filing of the application. At this stage, adjudicating authority is not in picture. And adjudicating authority here acts as per the report of the RP. So this was challenged in this petition. Yes.
To analyze the applicability of principle of natural justice, finally having put together the different strands of thoughts, one would deal in Part C with the constitutional validity of statutory provisions of Section 95 to 100, which are challenged in the instant proceedings, as opposed to the provision of Chapter 2nd of Part 2nd of IBC Part 3rd, especially deal with the insolvency resolution and bankruptcy for individuals and partnership form. Chapter 2nd of Part 3rd deal with the fresh start process, which is yet to be in force. Chapter 3rd of Part 3rd provide for insolvency resolution process. In Part 3rd of IBC, the IRP can be initiated by a debtor or a creditor acting as an individual entity or on behalf of other creditors. A debtor or a creditor is empowered to institute an application for initiation of IRP through ARP as well. The fundamental aspect which need to be noticed is that Part 2nd of IBC on one hand and Part 3rd on the other deal with the distinct processes for the resolution of insolvency. The former deal with the resolution of insolvencies of corporate entities, whereas the latter deal with the resolution of insolvency of individuals and partnership firms. The role of resolution professional in corporate as opposed to individual insolvency. It would now be necessary to advert to the role which is ascribed to resolution professional in Part 2nd and Part 3rd, while both the parts use the expression resolution professional. Notably, provision of Part 2nd contain a material differences from those of Part 3rd relating to the role and function of resolution professional. Maybe, in other words, upon the admission of an application which has been filed by the operational creditors or debtor, the provision for appointment of an IRP is triggered in terms of Section 16. Since Part 2nd of IVC deal with resolution of corporate insolvencies, the statute has implicated the role of adjudicating authority at the very threshold.
So basically, here they say that Part 2 is different, Part 3 is different.
Right.
So the role of the RP starts at the very threshold. So even before an application is admitted, the RP files a report. So this was constitutionally challenged. Yes. Next case.
DBS Bank Limited Singapore versus Ruchi Soya Industries Limited and another's. IBC question as to whether section 32 subsection 30 subsection 2 clause B subclause 2 as amended in 2019 entitled dissenting financial creditor to be paid minimum value of its equity interest was to be referred to larger bench for decision. Facts: the appellant dissenting financial creditor had extended financial debt of around 243 crores to the respondent corporate debtor, and the said loan was secured by first charge over the various assets. Meanwhile, a petitioner seeking CIRP was admitted and resolution professional was appointed. Thereafter, PAT submitted a resolution plan for rupees 4134 crore against the aggregate claim of around 8398 crore, represented approximately 49.22% of the total admitted claim of the financial creditor. The appellant requested the COC to take into account the liquidation value of such security while considering the distribution of proceeds and to make such distribution in a fair and equitable manner. In the 22nd COC meeting, the appellant's concern regarding the treatment and proposed payout was noted. However, the COC approved pari passu distribution of resolution plan, proceed with 96.94% voting share, and appellant had voted against the resolution plan. Thereafter, an application was filed before NCLT seeking approval of the resolution plan. Separately, the appellant challenged the distribution mechanism of resolution plan, proceed by way of an application before NCLT on the ground that it was entitled to minimum amount as payable in the event of liquidation at dissenting secured creditors, which had not been provided in resolution plan in terms of subsection 2, clause B, subclause 2 of section 30. The first issue that arises for consideration in this appeal is whether the amendment made in substantive portion of section 30
So
subsection
I'll tell the judgment in brief.
right.
So the judgment in brief is, suppose, because as you know, the committee of creditors comprises of only financial creditors who vote on the resolution plan. Now there are two types of financial creditors. Some vote in favor and some vote against. So those who vote against, section 30 subsection 2 says that dissenting financial creditors shall be paid liquidation value. Now the question is, suppose these dissenting financial creditors have got security also. So whether this liquidation value can be less than the value of security which is given to them? This is the precise question. I hope you have understood the question. The question is that the financial creditors are of two types. One who vote in favor of the resolution plan and second who vote against. Now these financial creditors may also be having security of the assets. Now the question is that in case of dissenting financial creditors, section 30 subsection 2 says that the dissenting financial creditors have to be paid the at least the amount which is not less than the liquidation value. This much we know. Now another angle to this is, if they are having security, so whether this liquidation value can be less than the value of the security which was offered to them. This is the question. Right. Now read the judgment and significance.
Okay. The Supreme Court held that dissenting secured creditors are entitled to receive the liquidation value of their security interest under section 30 subsection 2 clause B subclause 2 and not less. Liquidation value not less and not less. However, they cannot claim full value of their security or enforce it post resolution. The matter is referred to larger bench for authoritative resolution due to interpretive inconsistency in earlier ruling. Significance: this case reinforces the right of dissenting creditor, clarify the scope of section 32 subsection 2 clause B subclause 2 and seek to settle confusion caused by conflicting precedent. It aims to balance the creditor right with the finality and efficacy of resolution plan under IS.
Yes, please. Next case.
Greater Noida Industrial Development Authority versus Pravjit Singh, Soni and others. In the absence of a specific power in IBC, empowering.
So what I have done is, I have included the this link also. So
Right.
you can just copy this link and you can read the entire judgment.
Oh,
Yes, please. Please read. Yes.
even in the absence of a specific power in IBC, empowering NCLT to recall its order, NCLT can recall its order under its inherent power to secure end of justice and are to prevent abuse of process of court, notwithstanding that an appeal lay before NCLAT against order of approval of resolution plan passed by NCLT. The case background. The appellant, Greater Noida Industrial Development Authority, and respondent Prabjit Singh Soni and others, corporate debtors, Mr. JNC Construction Private Limited. तो ये ग्रेटर नोएडा इंडस्ट्रियल डेवलपमेंट a statutory authority under UP Industrial Area Development Act 1976 leased land to JNC Construction Private Limited for 90 years. The corporate debtor defaulted on lease payment, leading to GNIDA to file a claim of 43.4 crore as a financial creditor during the corporate insolvency resolution process CIRP. The resolution professional RP classified GNIDA as an operational creditor and requested resubmission of claim accordingly. GNIDA did not resubmit submit its claim, and resolution plan was approved by the NCLT on August 4, 2020. The GNIDA filed an application to recall the approval order and challenge its classification, which were dismissed by NCLT and subsequently by NCLT.
Yes.
The appellant, being a statutory authority constituted under Section 3 of UP Industrial Area Development 1976, acquired land for setting up an urban and industrial township. On 28 October 2010, one of the plot of land acquired by appellant was allotted by way of lease for 90 years to the corporate debtor for a residential project. The corporate debtor committed default in payment of installment and was served with the demand cum pre-cancellation notice. Meanwhile, CIRP petition was filed against the corporate debtor. Consequent thereto, claim were invited through a public announcement. Pursuant to public notice, the appellant submitted a claim of 43.4 crore, being unpaid installment payable towards the premium for the lease, and claim was set up by appellant as a financial creditor of the corporate debtor. However, the RP treated the appellant as an operational creditor and via email request the appellant to submit its claim in Form B as an operational creditor of the corporate debtor. The appellant did not submit its claim afresh as an operational creditor. Held that as per the provision of the IBC and on admission of a petition and declaration of a moratorium under Section 13, a public announcement is made inviting claim against the corporate debtor by a specified date. The manner in which the public announcement is to be made and claim are to be submitted is described in CIRP Regulation 2016. The use of the word a person claiming to be an operational creditor in the opening part of Regulation 7 and the word a person claiming to be a financial creditor in Regulation 8 indicate that category in which the claim is submitted is based on the own understanding of the claimant. Thus, there could be a situation where claimant in good faith may place itself in a category to which it does not belong. However, what is important is the claim so submitted must be with the proof as to what could form proof of the debt or claim is delineated in sub-regulation 2 of Regulation 7 and 8 of CIRP Regulation 2016. Supreme Court observation and ruling. Inherent power of NCLT, the Supreme Court held that NCLT possesses the inherent power to recall its order to prevent abuse of process and secure the end of justice. Even in the absence of explicit provision in the IBC, this authority is preserved under Rule 11 of NCLT Rule 2016. The classification as a secured operational creditor, the court recognized GNIDA as a secured operational creditor due to the statutory charge over the leased land under Section 13, 13A and 14 of the UP Industrial Area Development Act 1976. This classification entitles GNIDA to certain protection and consideration under IBC. The violation of Section 32, subsection 2 of IBC The resolution plan failed to acknowledge GNIDA's claim and did not provide for its dues, violating Section 32, subsection 2 of IBC, which mandate the operational creditor receive at least the amount they would in liquidation. The plan also incorrectly stated the GNIDA had not submitted a claim. Procedural lapses. GNIDA was not informed about the committee of COC creditor, the meeting denying its opportunity to participate in resolution process. This omission constituted a violation of principle of natural justice. Final judgment. As we have found that neither NCLT nor NCLAT, while deciding the application appeal of appellant, took note of the facts that the appellant had not been served notice of the meeting of COC and the entire proceeding up to the stage of approval of the resolution plan were ex parte to appellant. The appellant had submitted its claim and was a secured creditor by a operation of law. Yet the resolution plan projected the appellant as one who did not submit its claim, and the resolution plan did not meet all the parameters laid down in subsection 2 of section 30 of IBC. Read with regulation 37 and 38 of CIRP regulation 2016. We are of the considered view that the appeal of the appellant are entitled to be allowed and are accordingly allowed. The impugned order dated 24 November 2022 is set aside. The order dated 4th August 2020 passed by NCLT approving the resolution plan is set aside. The resolution plan shall be sent back to the COC for resubmission after satisfying parameters set out by the code as, as exposited above. There shall be no order as to the cost.
So, have you understood the case?
Yes.
The case is that this Greater Noida Industrial Development Authority, it is a secured operational creditor. But they filed their claim as financial creditor. And RP told them that you are not a financial creditor, you are an operational creditor. You file the claim accordingly. But GNIDA did not file the claim. And RP went ahead with the approval of the resolution plan without considering the claim of GNIDA. So it said that GNIDA has not submitted any claim. Now the Supreme Court said, please see what is written. Opening part of Regulation 7 says a person claiming to be an operational creditor. Similarly, regulation it says a person claiming to be a financial creditor. So they say the person who is filing the claim may not be aware whether he is a financial creditor or operational creditor. It is for the RP to see. So RP cannot say that if a person is filing a wrong claim, then he has not filed a claim. So this resolution plan was approved without considering this claim of GNIDA. So this resolution plan was set aside. And they said, you again send it back to the COC after including the claim of GNIDA. This is the case.
Right.
So the case actually highlights three important things. One is the wording, a person claiming to be an operational creditor, and the person claiming to be a financial creditor. That means this person is under the impression that I am a financial creditor or operational creditor. He may not be aware that what he is actually.
Right.
So RP cannot say that if you have filed your claim as financial creditor, then he can consider it as operational creditor and do it accordingly. But he cannot say that he did not file the claim. In this case, the RP said that GNID has not filed any claim, which was wrong. So this resolution plan, although it was approved, but it was set aside. This is the case. Next.
Yuva Agro Feeds Private Limited versus Punjab National Bank and others.
So today we will complete the Supreme Court cases. ज़्यादा नहीं है, 2-3 ही बचे. Yes.
Merely because liquidator has discretion of carrying.
Merely because.
Merely because liquidator has discretion of carrying out the multiple auction, it does not necessarily imply that he would abandon or cancel a valid auction, fetching a reasonable price, and opt for another round of auction process with the expectation of better price. Case
Actually,
background.
here the Supreme Court is saying that if the auction is valid, so liquidator, although it has the discretion of carrying out the multiple auctions, but if the auction is otherwise valid, because there is no end to fetching a better price, so that way liquidator will always say. So it says if the auction has been conducted out properly, there is no hanky panky, then that auction should be accepted, that bidder should be accepted, and you cannot go on rejecting the auctions in the expectation of fetching a better price. This is the case in brief. Yes, now please read this.
Corporate debtor Mrs. Amrit Feeds Limited, appellant Eva Agro Feeds Private Limited, respondent Punjab National Bank, and the appointed liquidator. On July 2021, an e-auction was conducted for assets of the corporate debtors. Eva Agro Feeds Private Limited emerged as a highest bidder, matching the reserve price of rupees 10 crore, and was issued an e-auction certificate confirming the successful bid. However, later that day, the liquidator cancelled the auction, invoking Clause 3 subclause K of e-auction process information documents and announced a fresh auction. Eva Agro challenged this cancellation before the NCLT Kolkata bench, which on August 12, 2021 directed the liquidator to proceed with the sale in favor of Eva Agro. The liquidator complied, accepting the balance sale consideration and issuing a sale certificate. Subsequently, PNB, a financial creditor, appealed the NCLT order to the National Company Law Appellate Tribunal, NCLAT, which on November 30, 2021 set aside NCLT decision and permitted the liquidator to initiate fresh auction. Fact. The CIRP was initiated against the corporate debtor and thereafter liquidation order had passed. The liquidator was appointed and by an email forwarding a sale notice for sale of the assets of the corporate debtor, and in e-auction process, appellant was declared a successful bidder. However, the liquidator had cancelled the sale e-auction as the assets was sold at reserve price and he wanted to sell assets at higher price. Aggrieved by the same, the appellant filed interlocutory application before the NCLT against the auction of the liquidator. The NCLT by an order allowed said application, holding that there was no irregularity in any auction process in terms of Regulation 33 and Schedule 1st of IBBI Liquidation Process Regulation 2016, and further directed the liquidator to send a communication to the appellant requiring him to deposit the balance sale consideration within time specified in e-auction notice. Meanwhile, respondent, being the financial creditor and had security interest in the said assets of the corporate debtor, filed appeal seeking to set aside the impugned order. The respondent had raised the issue that even if some bidder was highest, it did not amount to the auction had successfully been completed. Appellant held that appellant received a regulatory email from second respondent, that is liquidator. The language of the said email is quite important. The appellant was informed that it had won the auction for the subject property. The winning bidder order had been prepared and item was
ये
listed.
आवाज कहाँ से आ रही है पीछे से? जहां से
डॉक्टर
आ रही है
साहब
प्लीज
थोड़ा पीछे चले जाइए डॉक्टर
म्यूट कर
साहब.
लीजिए.
ऑन द appellant web page, if the appellant had any query, it was advised to contact the auction administrator. When the appellant requested the respondent number 2 for issuance of allotment letter in respect of this subject property, it received an email from the respondent number 2 on 21st July 2020 itself. The appellant was informed that in terms of clause 3, subclause K of e-auction process information document, he had cancelled the e-auction held on 20th July 2021. Appellant was informed that the liquidator would come up with a fresh e-auction for sale of the subject property. No reason were assigned by the liquidator for cancellation of e-auction held on 20th July 2021. The appellant was simply informed that e-auction was cancelled in terms of clause 3 subclause K of e-auction process information document. Clause 3 subclause K only declare that the liquidator has absolute right to accept or reject any or all bids, adjourn or postpone or cancel the auction, etc. at any stage without assigning any reason therefore. Supreme Court judgment September 6, 2023, EVA Agro Feed Private Limited appealed the NCLT NCLAT decision to Supreme Court. The key observation and ruling by the Supreme Court were arbitrary cancellation. The court held that liquidators' cancellation of the auction was arbitrary and lacked valid justification. The expectation of obtaining a higher price in the subsequent auction did not constitute a sufficient reason for cancellation.
So here is the question is that liquidator also cannot be arbitrary. भाई law में क्या लिखा है कि they have the right to accept or reject. But once a proper bid has been completed and उसको बोल भी दिया कि भाई you are the successful bidder and then it was cancelled.
जी,
Yes.
finality of the auction. Once the highest bid is accepted and sales certificate is issued, the auction process attains finality. The liquidator cannot unilaterally cancel the auction without substantial and justifiable reason. Supreme Court of IBC provision, the court emphasizes that the provision of IBC and Insolvency and Bankruptcy Board of India (IBBI) regulation take precedence over the terms outlined in e-auction process information document. Therefore, any clauses allowing cancellation without reason cannot override statutory mandate. The restoration of NCLT order, the Supreme Court set aside NCLAT order dated November 30th, 2021 and restored NCLT order against August 2021, thereby upholding the sale in favor of EVA Agro Feeds Private Limited. Significant, the judgment reinforces the principle that liquidator must act within the bound of IBC and cannot arbitrarily cancel auction based on speculative expectation. It upholds, it upholds the sanctity and finality of duty conducted auction process, ensuring fairness and transparency in insolvency proceeding.
Sure. Next.
In the matter
थोड़ा
of
सा ही है,
Hari
5 मिनट
Babu,
आप वेट करेंगे, 5 मिनट में कंप्लीट हो जाएगा. ज्यादा नहीं है, दो
okay, no
जजमेंट.
issues.
यस.
जी. In terms of section 29A subsection C time frame, a period of 1 year should elapse from the date of classification as non-performing assets (NPA) and cut-off date for determining whether resolution applicant was disqualified in terms of section 29A would be date of submission of resolution plan and not the date of commencement of CIRP. Case background: corporate debtor Sri Akshaya Infra Con Limited, an appellant Hari Babu Thota appointed as resolution professional RP. Timeline April 6,
So here,
2023.
before reading this judgment, if we read section 29A, subsection C, what it says? Section 29A C, if we see, because this ineligibility, we are all clear that it has to be seen at the time of submission of the resolution plan. Now 29A C says that at least a period of 1 year has lapsed from the date of such classification till the date of commencement of the CIRP. ठीक है?
Okay.
So now this question is that whether it is the date of submission of the resolution plan and not the date of commencement of the CIR. What is the cut-off date for determining whether a resolution plan was disqualified? It is the date of submission of the resolution plan and not the date of commencement of the CIR.
Okay.
This is the judgment actually. So now let us see the
Judgment.
what it says.
H.
Actually, the idea is that 1 year should elapse from the date of classification as NPA. So, in the factual scenario, it is stated that there are no bank dues outstanding which would at all invite a concept of NPA, much less the period of 1 year. Okay. So, they said that this 1 year has to be. So, when this period of 1 year should lapse. So it says it has to be seen with reference to the submission of the resolution plan. So this judgment provides clarity on the applicability of section 29A and section 240 capital A of IBC concerning MSMEs. It underscores that promoters of MSMEs are not disqualified from submitting resolution plans solely because the MSME. So there is another angle to this, that because section 240 capital A, we all know that section 240 capital A talks of the CIRP of MSMEs, and it says that section 29A subsection C and 29A have to be ignored for the purpose of considering the eligibility or ineligibility of a resolution applicant. ठीक है ना? Now suppose this MSME certificate was obtained after the commencement of CIRP. Then whether still that section 240 capital A benefit will be given? The answer is yes. So they say in this case, MSME registration was obtained after the commencement of CIRP, provided the registration is in place before the submission of the resolution plan. So it was obtained after the commencement of CIRP, but before the submission of resolution plan. So they say this 240A capital benefit will be given. It will be given. ठीक है, ये केस था. Now last case, State Bank of India and others versus the consortium of Mr. Murari Lal Jalan and Mr. Florian Frisch and other. So this is Jet Airways case. The case, it was the Jet Airways, it ceased its operations and CIRP was initiated and resolution plan was submitted. A consortium led by Mr. Murari Lal Jalan and Mr. Florian Frisch. So they submitted a resolution plan and it was approved by the COC also with 99.22% majority. And they gave, what were the key terms of the plan? They gave an unconditional commitment to infuse approximately 1090.1 crore in cash. Settlement of dues amounting to 52 crores for workmen and employees, and plan was not contingent upon the sale of Jet Airways assets. But they did not fulfill the key terms of the plan, this resolution applicant. So, adjustment of performance bank guarantee. So they said, the resolution applicant say that we have already given the 150 crore performance guarantee. As you all know that by virtue of section 30, the successful resolution applicant is required to submit a bank guarantee. So here the resolution applicant was saying that I have already given the bank guarantee of 150 and you adjust this 150 crore against this 10 90 crores. ठीक है. The court examined whether the performance bank guarantee of 150 crores could be adjusted against the first tranche. ठीक है. First tranche payment was 350 crores. It held that such an adjustment was impermissible under the terms of the resolution plan because performance bank guarantee is given so that the plan is successfully implemented, and it is for the resolution plan period, the implementation period. Now the resolution applicant is saying that you adjusted against the first tranche of payment. So this is impermissible. Then non-compliance. The court observed that JKC failed to fulfill its obligations under the resolution plan, including the infusion of first tranche of 350 crores and payment of CIRP process costs such as airport dues. Because every resolution plan, you have read section 30. So every resolution plan must provide for the payment of CIRP costs. So this failed on both accounts. It did not pay the airport dues which were included in CIRP cost, and it failed to fulfill its obligation for the first tranche of payment. They raised the argument that you adjust our 150 crore bank guarantee, which was not permissible. है ना? So, given the JKC's repeated defaults and non-compliances, the court emphasized that timely liquidation is preferable over an indefinite resolution process. So, it directed the liquidation of Jet Airways under section 33, subsection 3. So, although the plan was approved, but still the NCLT, they ordered liquidation. So, this judgment underscores the importance of strict adherence to the terms of the approved resolution plan. It clarifies that PBGs cannot be adjusted against payment obligations unless explicitly permitted. That decision also highlights the judiciary's commitment to ensuring timely resolution or liquidation to maintain the efficacy of the insolvency framework. ठीक है. तो ये केस था. काफी है ना आज के लिए. बाकी हाई कोर्ट केसेस कल करते हैं.
ओके सर.
ओके जी.
ओके, गुड नाइट सर.
गुड नाइट. चलो सिंह साहब, काफी अब मदद कर दिया आज आपने मेरा.
तो मेरी भी तबीयत सर 2-3 दिन से गड़बड़ चल रही है. आज भी नॉट आज वाज फीलिंग. हमने कहा सर बोल रहे हैं तो करना पड़ेगा.
नहीं, बढ़िया है, बढ़िया बढ़िया. थैंक